So he's not a good candidate for probation. I'm not giving him probation.
Well,
And
Judge,
does he not understand what no contact means? No contact means no contact. Charge where you're choking her. There was a protective order in place, and you were calling the complainant from the Bexar County Jail. Mr. Ross, in each cause number, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I did.
And each cause number, did you review the true bill of indictment with your attorney? Did you understand it? And cause number 2025 CR 003533, you're charged with assault, family, household, impeding breath or circulation. And in cause number 2025 CR 004086, you're charged with violation of bond or protective order 2 times or more within 12 months as a third-degree felony. Range of punishment in each of those cause numbers is anywhere from 2 to 10 years in prison and up to $10,000 fine. In each cause number, did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes.
In each cause number, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. State is silent on your application. The cases were run concurrently. There's to be no contact with the complainant. And in the cause number ending in 33, there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Then in cause number 2025 CR 003533, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2025 CR 004086, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right. So in the cause number, and maybe I don't see it, in cause number 86, I don't see the other dates. I don't see the December 6th, December 11th.
What those dates are referring to, which I guess we could figure out how to put in the stipulations where those were days that the defendant called the victim from jail. So those would be reported to jail.
All right. So
and we've been provided with those, Judge.
I'm sorry.
We've been provided those.
Well, are you stipulating that because he pled no contest? Is there a stipulation that he made phone calls to the complainant from the jail on December 6, 2024 and December 11, 2024? And December 15, 2024, December 20th, 2024, and January 25th, 2025?
The last date was not, that was the part of the report attachments where he had allegedly had contacted her through social media after being released from custody.
All right.
So as far as that, Judge, we're pleading no contest. My client has no prior offenses.
No. I'm trying to see if there's.
I'm trying to get there. As to our application we are applying for deferred adjudication. And so because of that, I would not want him to make any stipulation. So that's why I asked him to plead no contest. Because if the court should grant him deferred, then.
Well, here's the thing. I don't have that in the stipulations to prove the 2025 CR 004086. Now, if somebody wants to amend this and attach jail calls, they can attach it, but I don't have enough proof in here for these other dates. The only date that I have in the stipulated evidence is I have a date from January 5th for violation of protective order, but the other dates I don't have in here. Sure. So if y'all want to step back, you can, but in cause number 2025 CR 003533, the court is finding that there's sufficient evidence to find you guilty. The court will defer finding of guilt. It takes about 8 weeks to 12 weeks for a PSI. If you would like to have him come back without a PSI, but just have time to call witnesses, you're more than welcome to do so.
So I've conferred with my client, and I've also contacted family members, and my client wishes to waive PSI and just have the court. And that was why we took a little bit of a recess, Judge, before we got on the bench, is just to confirm the criminal history. And so at this time, we're asking the court to waive PSI, and we proceed with sentencing today.
All right, and counsel, Where are you saying this?
Can you repeat the dates, Judge?
The dates that
That they're in question?
the dates that are in question for the court are, I have a December 3rd. I have a December 5th date. So December 5th and count one, that's paragraph 1. So I'm looking for the December 6th date. I don't see the December 6th date in here. And then there's a December 11th date. I don't see the December 11th date in here. Okay, so where's the,
I think she downloaded it, put it on the disk to have as part of the stipulation. If need be.
Well, December 2nd was the date of offense. I was just trying to confirm that, Judge.
well, so here's the thing. If he's not going to stipulate that what's in the indictment, the dates, then we can't proceed. I can't proceed on those dates. And if there's no additional information that's given to the court, then the court is going to find him not guilty of this because,
And Your Honor, if I may, Ashley Jones for the record, all that's required for the statute is 2 offenses within a 12-year period. The first offense is going to be December 5th, which is listed in the report, and then the second offense will be the January 25th date, which is in the report. So that would be 2 violations within a 12-month period, and we can scratch or amend the.
all right, so y'all want to admit, all right. So we're back on the record. Well, I don't even see the January 25th date in here.
It says January 23rd, yes.
Well, that's they have it listed as report time. I don't know if that's the report time when they made the police report or the report time for this offense. Wait, just one moment. Let me see. All right. You're correct. So that on or about date time is the time when they filed the report, but also the time when she's saying it happened. So the court will find there's sufficient evidence to find you guilty in 2025 CR 004086. The court will defer finding of guilt as you apply for deferred adjudication. And you're saying that you wish to waive PSI?
That's correct.
All right. What do you wish to say on behalf of your client?
Your Honor, my client, he's 27 years old. He is not native to Texas. He's from Indianapolis, Indiana. I'm sorry? Chicago, Illinois. I apologize, but he, as mentioned before, he's 27 years old. The victim and him are obviously very familiar. They've been together since they were children. So I think since they were like 16 years old. Is that right? 16? 15. Since they were
All right. Does he
15.
want to testify?
No, Judge. Let me just finish. I'm so sorry.
All right. So you can't get information from him, then turn back to the court to give whatever information he's given you if he's not going to testify.
Okay. I'll just
All
proceed.
right.
I'm sorry, Judge.
No problem.
And they do have 3 children together. And obviously they've had a myriad of things happen, I guess, in their lives, and they have both matured and progressed. And my client wishes to accept responsibility. He understands that the only way he's going to see his children, because that was another thing that we talked about, was that there will be a no contact order. That is something that obviously he's vehemently opposed because he does have 3 children. And so I did advise him that this would be part of the plea agreement. And if he wants to hire a lawyer and, get some custody issues and orders in place so that they can go around that order, in order for him to be able to see his children, because obviously the state is not asking for a no contact order with the children. It would only be with the mother, the natural mother, which is the victim here. I have spoken to his father. I am not sure if yesterday he was on the Zoom and standby, and I mentioned him that he would at the same time today. And I don't know if he's in the waiting room or not, but notwithstanding, my client does want to go forward. His father obviously speaks very highly of him. Unfortunately, he did get arrested in February 27th, which is when he got booked for the last time. So he's been obviously in custody for almost going 3 months now. He's got health issues at the jail, Your Honor. He's got psoriasis. He lost about 110 pounds in those 3 months. So he's had some kind of health limitations. And so a lot of that is going into why we have this agreement. Obviously, I've explained to him multiple times, that we could ask for a jury trial from the court. But given the history with these people, that obviously he wants to accept responsibility, and he's wanting to do that today, Judge. And with respects to just putting it on the record, I do want to state that we took a little bit of time going over the criminal history. There was a jury trial that happened in December of 2019 in Indianapolis, Indiana. So that's why I'm sorry I was confused about the city. That there was an actual jury trial, and he was adjudicated not guilty with the same victim. There was also I want the court to take judicial notice of clause number 2025 CI 04103. There was an application for protective order that was made by the victim February 25th, 2025, and it was non-suited in April 17th of 2025. My understanding, and prosecutor wouldn't really talk to me too much with respects to the protective order, Ms. Colon, but she did confirm that it was non-suited due to her leaving the state. So the victim,
Due to what?
the witness leaving the state.
Okay.
So as we stand here today, we have obviously my client hasn't had any contact with her since then. And then, but she has been in contact with the state, which obviously, we know that is for a fact, but obviously he's very concerned for his children. He wants to know their whereabouts. And he did meet with a recruiter, and I did speak to him on the phone. He would not come in for the PSI. His name is, let me see, his name is Eggerson is his last name, Sergeant Eggerson. And I did call the number. Let me see, on Potaranco Road. It's 11223 Potaranco Road. And unfortunately, Mr. Ross was in the process of being recruited to the Army. And so obviously he understands that accepting responsibility for this charge, and should the court grant him deferred, he will not be able to possess a weapon while he's on deferred. But the hope, I guess, is that once he's completed the deferred, is that he'll be able to enlist at that time. So our agreement right now is 4 years. Now the court can give him probation, the court can sentence him, or the court can give him deferred, which I believe he's legally entitled to because he has no convictions.
What do you mean he's entitled to deferred adjudication?
Okay.
Legally?
Well, I would ask the court to take that into consideration, that he has no legal convictions under any other ordinary circumstances. He has no prior offenses.
Okay, but
convictions. And so,
but if you're saying
he's a first-time offender,
all right, but if you're saying he's legally entitled to deferred adjudication on this case,
I have no statute.
Oh,
If the court, I have no statute, but I'm just saying, as a matter of principle, as a matter of, mercy on my client, the court, I should hope, at least, because again, he's also been in contact with, being recruited, that he would be granted deferred adjudication. And, he wants to move on with his life. He wants to start probation. He understands that should the court grant him probation, he'll have to be here for 45 days, right? You understand? You understand it? And that if he wants his probation to be transferred to Indiana, it'll have to be transferred within that time frame.
all right. So what I can
And
tell
they'll
you,
have to accept that
he's not a good candidate for probation.
He's not.
No, he's not. And let me just tell you why. Based upon everything that I've seen, there was a protective order in place, and you were calling the complainant from the Bexar County Jail. I mean, does he not understand what no contact means? No contact means no contact. And then we have this charge where you're choking her. So he's not a good candidate for probation. I'm not giving him probation. In each cause number, I'm finding him guilty. I'm going to sentence him to 4 years in the prison, give him credit for any time served. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no contact with minors. And cause number ending in cause number 2025 CR 003533. There's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in each cause number? With your attorney, did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because one of these cases carries an affirmative finding of family violence, and also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Sorry, may I speak to my bad, please?
Your attorney said that she did not want you to speak. The court has passed sentence.
I didn't know that I couldn't. I thought I had the whole time to testify. I thought she would.
I asked you if
All
you
right,
were
so,
jury trial.
they're going to take you back. If
Can I
there's something
please-
else you all want to discuss, if you want to file a motion, you can file a motion and the court will hear that
Please
motion.
speak on my behalf. Can I please speak on my
I don't know what you-
behalf? I just want to testify.
You entered a plea to kidnapping of no contest on March 20th, 2023. According to the plea, punishment is to be assessed at 10 years in the prison. The state opposes your application. They're taking several cases into consideration. There's an affirmative finding of family violence. Have parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections, state?
No objection.
Defense?
No, Your Honor.
State, any witnesses?
I can have one moment now.
Defense, any witnesses?
Other than the defendant, no.
All right, would you like to, are there witnesses?
Yes, Your Honor.
Oh, you want to call her?
I thought it was for victim impact statement after sentencing. We will be calling her as a witness.
I can't hear you, Mr. Burr.
Yes. We will be calling her as a witness, Your Honor.
All right, call your witness.
Mr. Tovar.
Your Honor, and I would object to her testifying to anything that we would consider to be a victim impact statement that should be presented to the court after the judge sentences.
Okay. All right, call your witness.
Your Honor, we call Jennifer Tovar.
All right, Ms. Tovar, if you come forward. Yeah, come up. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. I'm gonna need you to speak up so the court reporter can hear. State your name for the record.
Jennifer Tovar.
State.
Ms. Tovar, you are the victim in this case against Mr. Zaragoza.
Yes, sir.
And you are aware that he has applied for deferred adjudication with probation.
I am.
And are you in what are your feelings if the defendant were to be granted probation? Objection.
And what's your objection?
He's telling you what effect your decision will have on her. And we don't want her influencing.
All right, that'll be sustained.
Do you want the defendant to be released on probation? Objection, Your Honor, it's the same thing.
Sustained.
I'll ask the court to disregard, of course.
Oh, yes, it's disregarded.
Then, just 1 second, Your Honor. Ms. Tovar, on December 21st of 2021, can you tell the court what happened?
So I visited Ray to pick up Christmas money because me and the kids were living in Atascosa County due to CPS case that we had for domestic violence.
Your Honor, I object because it's repetitive. Everything about that offense is in the police report, which was presented to the court as part of our plea package.
All right. So just so all parties are aware, I've read the stipulations in its entirety. I always reread those before sentencing, and I read them once I make a decision on whether there's sufficient evidence to find somebody guilty. And I've also read thoroughly read the TAP evaluation. So you can ask your next question.
Yes. Ms. Tor, have you had any contact with the defendant since these allegations?
Yeah, so he calls the house and speaks to myself and the kids. I guess when he can, because he doesn't have
No,
any
there's objection, non-responsive. She answered his question.
All right, that'll be overruled.
You can continue.
Oh, so he has to use, I guess, a pre-collect call that he has because he doesn't have any money on the account to call us.
Okay.
So, and I don't fund it anymore. I just did for a little while around Christmas time, but no, it's only when he gets a collect call he can call.
And Ms. Tovar, you currently have a protective order against the defendant?
I do.
And do you feel that is sufficient to keep you safe?
No.
And why is that?
Objection, Your Honor.
What is your objection?
She's commenting on what your decision will ultimately do to affect her and her children.
All right, that'll be overruled. You can answer the question.
No, I don't think so. It didn't in the first place. It didn't. Ray was still coming around and still calling.
And while these cases were pending, you did have a no contact order against the defendant, correct?
Right. But I was told that to let him talk to the kids. So even though we have a no contact order, that's why, I was taking calls so that he could talk to the kids. I didn't want anybody to say that I wasn't allowing it. Yeah, because they're not part of the protective order. It's just me.
Thank you. Nothing further, Your Honor.
All right, defense.
No question.
All right, thank you. State, do you have another witness?
No other witnesses, Your Honor.
Defense.
Just the defendant himself.
All right, if you'll come forward. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Zaragoza Ray Tawada Jr.
All right, defense.
Thank you. Mr. Tovar, did you want to address the court with regard to why are you requesting her to give you probation?
Yes. I feel that given probation, I could complete probation. As you know, I haven't been in trouble before, Your Honor. This is the longest I've been in jail. I feel that I've made a mistake. And if you read the current note I wrote to you, Your Honor, it describes more of my feelings. I want to apologize to the court and I want to apologize to my wife, who we've been together 11 years, 10 years, been with the family 15 years. All I know is my family, Your Honor. And I'm asking for your leniency and your mercy, Your Honor, for probation classes so I can better myself.
Thank you.
All right, state, any questions?
Yes, Your Honor, briefly. Mr. Tovar,
Yes, sir.
in this case, you're charged with a violation of a bond of protective order, as well as a repeat violation of a bond of protective order, in addition to the kidnapping, correct?
I am.
He was.
I was.
And given that there was a no contact order protecting Ms. Tovar from you, you violated those no contact orders.
That is wrong. She came to my home and moved in with me because she had no place to live. I wasn't going to leave my wife and my kids out on the street. So I did not violate it. She came to me, and that's how I violated it.
But you were made aware that any contact with Ms. Tovar would be a violation of those bond conditions, is that correct?
I was aware, but I was not going to leave my kids and my wife out on the street, sir.
In this kidnapping case, you did tie up Ms. Tovar with duct tape, is that correct?
No, that is incorrect.
And you said you've never been in trouble before, but you did have a case out of Atascosa County, Texas, for a violation of bond of protective order in that county as well, is that correct?
That was for phone calls for talking to my children, which I had the right to do. And if you check the records, it says for electronic communication, I was allowed to talk to my kids.
And you did abscond during that case on February 9th of 2023, is that correct?
Is that?
You just didn't do anything and you failed to report.
I was in jail.
Okay.
It's not that I failed the report, it's just I couldn't go.
Okay.
I was in custody. I'm sorry, I said during that incident, I was in custody, so I couldn't go over there.
I have no further questions, Your Honor.
Any further questions?
No,
All right, any other witnesses?
no, Your Honor.
All right, the court will hear argument. State, you're opposed.
Yes, Your Honor. We're opposed to the defendant being granted probation. While you heard from the victim that she does not feel protected just by the no contact order, and that the fact that he was charged with a repeat violation of court order bond condition twice, which are being taken into consideration in this offense, Your Honor, shows that the defendant, whatever the allegations were, completely disregarded the court's order, and telling him that he's not supposed to have any contact with the complainant.
But what about his saying that she came to live with him?
But Your Honor, regardless of what the allegations are, if he knew that he had these charges pending.
No, I understand that, but isn't that mitigating the fact that she chose to go and live with him? Now, I understand financially there are issues, but a no contact order, of course, it's a document, it's on paper, and the defendant knows they're not to have contact with them. But what about his saying that he had a choice? Either his children were going to be on the street with her, or either she was going to come and live with him. But it doesn't appear in that situation, if it's truthful, he didn't go and have her come live with him. She decided to go live with him.
That is correct, Your Honor. And while it may be mitigating there, knowing that he did have that no contact order, there are other options for Mr. Tovar to be able to take care of his children without having contact with the complainant. He could have taken the children while Ms. Tovar went to go find another living arrangement.
Do you know she wanted him to take the children and leave without her children?
That I'm not aware of, Your Honor.
Okay.
But given that, and given the allegations in this case, Your Honor, we don't feel that we do feel that the defendant is a danger to Ms. Tovar if he were to be granted probation. And so we'd ask that you deny the defendant's application to take it.
All right, defense.
Thank you, Your Honor. As you know from reading the pre-sentence report, my client doesn't have an extensive criminal history. These offenses, although serious, have really made him take a step back to reassess his life and how he lives his life and how he treats his family. And I think he's expressed rather eloquently in the letter that he tendered to the court. He's going to do whatever it takes to fix himself. He's even read the PSI where the recommendations on the tap eval that if granted probation, he should be placed in a program to help make sure he's no longer drinking excessive amounts of alcohol. And he wants to fix himself in that way. And he's been taking some classes in the jail since he's been in jail. It's been a couple of months now to help him control his demeanor, his anger, everything. He's trying to fix himself.
Okay. All right, this is what the court is going to do. The court is going to deny your application, find you guilty, sentence you to 9 years in the prison, give you credit for any time served. Take in consideration 2022 CR 7416, 2023 CR 1300, County Court Cause number 698311. There's an affirmative finding of family violence. There's a $1,500 fine, time and money to run concurrent, and there's to be no contact with Jennifer Tovar. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Also, because this is a felony conviction, and also because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You have to make better decisions in your life.
Yes, Your Honor. This is just a mistake, Your Honor. I wish.
Well, no, it was a choice, and it was a bad choice.
Yes, ma'am.
And here's the thing. I understand about protective orders.
Yes.
I understand that sometimes the person who the protective order is supposed to protect, they decide that they're going to go live with the person that there's a protective order against. And then there's an issue that happens, and then everybody calls the police, and here we are.
Yes.
So
ma'am.
when you have a protective order, you are the person who are responsible. And if somebody wants to come live with you and there's a protective order in place, you need to say no. Do you understand?
I do now, Your Honor.
Well, I mean, you knew beforehand. You just decided, maybe we can work this out. Here's the thing. She doesn't want you anymore. That relationship is over. You can consider her on paper, unless y'all got a divorce, she's still your wife. But in reality, she's not your wife anymore. She does not want to be with you. Do you understand? Do not call her from the jail. Do not call her from the prison. Do not contact her. And if you want to see your children, and Ms. Burke does a lot of civil work, if you want to see your children, then that needs to be done through a third party, but it's not to be done through Ms. Tovar. It's like you don't even know her. Do you understand?
Thank you, Your Honor.
You're welcome. Christopher Reyes.
All right, we have victim impact.
All right, that'll be at the end.
A Texas courtroom presided over by Judge Stephanie Boyd heard the sentencing of a man charged with kidnapping and violating a protective order multiple times involving his wife. The defendant had previously entered a no contest plea and was requesting probation, stating he had no significant criminal history and had been working to improve himself while in custody. The victim testified that she did not feel protected and that ongoing contact had occurred despite the court order. The defendant denied the most serious allegations and claimed the contact happened due to difficult family circumstances. After hearing from both sides, Judge Boyd denied probation, found the defendant guilty, and sentenced him to 9 years in prison. The judge reminded him that a protective order means full responsibility for maintaining distance and encouraged him to rebuild his relationship with his children through proper legal channels.